Hi, I am attorney Chris Batan Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes.
Hello everyone. So for this video, we will be talking about accession. What is accession? Accession is actually also one of the rights of an owner. So in the two previous videos on property, we already talked about the different rights of an owner: the right to use, the right to possess, the right to the fruits, the right to dispose of the thing, and we even talked about the right of the owner to recover possession or ownership of the property if he is dispossessed. So for this video, we will talk about accession. What is accession? How is it different from an accessory? We will also be talking about right of an owner to the fruits of the thing. And we will also talk about what would be the consequences if the owner would build on his property and he uses the materials of another. So essentially, this video lecture will cover articles 440 to 447. So let's begin the discussion. The right of accession. It is the right of the owner of a thing, real or personal, to become the owner of everything which is produced thereby, or which is incorporated or attached thereto, either naturally or artificially. So, being an owner of a thing, you also have the right to own whatever is incorporated or attached to that thing, whether the attachment be done naturally or it be done artificially. Article 440, it says the ownership of property gives the right by accession to everything which is produced thereby or which is incorporated or attached thereto, again, either naturally or artificially. Now, what is the difference between accession and your accessory? So, accession are the fruits of or additions to or improvements upon a thing, which is the principal, and accessory are things joined to or included with the principal for the latter's embellishment, better use, or completion. So when you talk about accession in this chapter, you're actually talking about the building, the planting, and the sowing, or alluvion, or accession natural, or avulsion, or the change of course of rivers, or the formation of islands. So these are the improvements upon the thing. So when you make buildings upon a parcel of land, then it makes it more useful. Okay? While accessory, it is only for embellishment or for better use or completion, like the key of a house, the frame of a picture, bracelet of a watch, machinery in a factory, and bow of a violin. What are the different kinds of accession? You have accession discreta and accession continua. When you talk about accession discreta, you're actually talking about or referring rather to the fruits of the thing. It could be natural fruits, it could be industrial fruits, or it could be civil fruits. Now, what do you mean by natural fruits? They are the spontaneous products of the soil and the young and other products of animals. What are industrial fruits? There's a thin line between natural and industrial fruits. When you talk about industrial fruits, there is work involved. This may still refer to young of animals, it would still refer to fruits, but this time there is industry involved, unlike your natural fruits. Now, when you talk about civil fruits, you refer to rents, you refer to interests, to income. So these are what you mean by civil fruits. What is accession continua? It is the right of the owner of a thing to own the things attached or incorporated to the thing. This is based on convenience and necessity, while accession discreta is based on principle of justice. So we're going back to accession continua. That refers actually to the building of an improvement on a property. See, it says there, the right of the owner of a thing to own the things attached or incorporated to the thing. Accession continua may be classified further with respect to real property and also with respect to personal property. Let's cover first accession continua with respect to real property. That's accession industrial and accession natural. So this is what I mentioned, building of an improvement over the property. So if you have a parcel of land, you build a house thereon, or you construct a building, that's accession industrial. Or if you make any plantings or sowings thereon, that's also accession industrial. Accession natural or natural accession, that's that we will talk about alluvion, avulsion, change of river course, and formation of islands. It's another chapter. For accession continua, also with respect to personal property, another chapter on that. You have conjunction or adjunction, you have commixtion or confusion, and you have specification. So this is what I mentioned earlier on. So natural fruits, spontaneous products of the soil and the young and other products of animals. Industrial fruits is what we mentioned, thin line between natural and industrial. The only thing separating it is that there is labor that is incorporated there too. There's now work involved. And then civil fruits, as we mentioned, rents of buildings, the price of leases of lands and other property, and the amount of perpetual or life annuities or other similar income. Okay, now, what is the general rule? When we talk about the right of an owner to the fruits, the general rule is all fruits belong to the owner of a thing. That is, again, one of the rights of an owner, the right of accession, the right to own the fruits. The exceptions, however, meaning you're the owner of the principal thing, but you are not entitled to the fruits. These are the exceptions. Possession in good faith by another, when there is a usufruct, the lease of rural lands, and in cases of pledge and antichresis. Now, let's talk about the obligation of the recipient of the fruits. That's Article 443. It says, he who receives the fruits has the obligation to pay the expenses made by a third person in their production, gathering, and preservation. What does that mean? It means that you are the owner of the property and you are enjoying the fruits, but somebody else produced, gathered, and preserved those fruits. Okay? In the interest of justice, the law tells you that while you may be the owner of the land, while you may have the right to the fruits of that land, but if you are not the one who spent for the production, for the gathering, and the preservation of those fruits, then the law says you must pay the expenses that was incurred by the third person. Now, will the owner be excused to pay the expenses if the person producing, gathering, and preserving the fruits did so in bad faith? In other words, somebody else, a third person, not the owner of the land. You own the land. And then here comes a third person who planted on the land, okay? Planted, took care of the harvest, produced, and gathered. But then we said the fruits must belong to the owner of the land. And he did so in bad faith. Will the owner be excused from not paying him because he did so in bad faith? Now, you look at Article 443. 443 does not make any distinction. The owner cannot excuse himself from his obligation by alleging bad faith on the part of the possessor because Article 443 makes no distinction. And because the expenses would have been spent for by the owner anyway, by gathering them, by preserving them. These are called necessary expenses. And whether or not a third person may have spent for it, the owner would have spent for it just the same. Okay? Now, what if the expenses exceed the fruits? Should the owner still pay the excess? Meaning, the owner now gathered the fruits. Fruits, let's say, is valued at 100,000 pesos. But the expenses in producing them, in preserving them, in gathering them, amounted to 150,000 pesos. Okay. Will the owner still pay for those expenses when the expenses is 150,000 and the fruits are only valued at 100,000? Again, yes, because the law does not make any distinction. The law does not say that if the expenses are more than the value of the fruits and the owner will no longer pay the third person. No, it does not make any distinction. And so the owner must still pay. Is there a way where the owner may excuse himself? For example, the owner is your client. The owner tells you, attorney, can I not pay? Because I will be at a loss. The fruits are just valued at 100,000, but the expenses are more than that. It's 150,000. Yes, there is a way. If the owner will allow the possessor to complete the harvesting and gathering of the fruits for himself, then he need not pay. In other words, the third person who produced, who preserved them, who gathered them, he will let that third person collect and harvest and gather and keep the fruits for himself. And so, in that way, he need not pay for the expenses. Now, let's talk about the right of accession with respect to immovable property. General rule, Article 445, whatever is built, planted, or sown on the land of another, and the improvements or repairs made thereon, belong to the owner of the land, subject to the provisions of the following articles. 445 and 446 gives you the general rule as to who owns anything that is built, planted, or sown on the land of another. So, if you own a land and you see a building there that is being constructed, or you see plantings on that parcel of land, the general rule is it will belong to you, the owner of the land. And 446, okay, in support to 445, also tells you that everything that you see on that land, any works, sowing, or planting, they are presumed to be made by the owner of the land and at his expense. That's the general rule. The exception is if the contrary is proved, that a third person has spent on the construction of the works or on the plantings or of the sowings. So basically, the principle then is that the accession follows the principle, meaning whoever owns the principle is also the owner of the accession that is found on the principal thing. Article 447 gives you a situation where the landowner uses the materials of another. So you have A who owns the land, okay? And then he makes constructions on the land. He makes, let's say, a house on the land using the materials of B. Again, the owner is A. He builds on his property using the materials of B. What does 447 tell you? It says, the owner of the land who makes thereon personally or through another plantings, constructions, or works with the materials of another shall pay their value, and if he acted in bad faith, he shall also be obliged to the reparation of damages. In other words, if you use the materials of another, whether you be in good faith or in bad faith, you are to pay for the value of those materials to the owner of the materials. Okay? It does not make any distinction. If you use the materials of another, even if in good faith meaning you thought that the materials were yours, but it's actually not. So whether in good faith or in bad faith, if it belongs to another person, you have to pay the materials. If, however, you acted in bad faith, you knew that the materials were not yours, but you still use them to construct, then in addition to paying the value of the materials, you are obliged to pay damages. The owner of the materials, however, shall have the right to remove them only in case he can do so without injury to the work constructed or without the plantings, constructions, or works being destroyed. Now, remember, the owner of the materials is given the right to remove the materials, but subject to the condition that his removal of the materials will not do injury or will not cause damage or injury to the work constructed or without the plantings, constructions, or works being destroyed. Granting that the landowner who used the materials used it in good faith. This is because of the principle on accession follows the principal. So since the owner of the principal built something on his property, the general rule is whatever he builds on the property will belong to him. But the problem now here is he did so by using the materials of another. Now, if both are in good faith, your landowner is in good faith, believing the materials were his, and the owner of the materials was also in good faith. He did not know that somebody else used his materials. The owner of the materials will now have a right to remove. But of course, his right is inferior to the right of the owner of the land, because he can remove them only if it does not cause damage or injury. But if the landowner used the materials in bad faith, what does the law tell you? It tells you that the owner of the materials may remove them in any event with a right to be indemnified for damages. So this will show you more clearly the rights. So if the owner of the materials is in good faith and the landowner is in good faith, then as what we mentioned, landowner must pay the value of the material, but the owner of the materials may remove if he can do so without injury. If the owner of the materials is in good faith, but the landowner is in bad faith, the landowner must pay the value of the materials plus damages. And as we mentioned, the owner of the materials may remove his materials in any event. Now remember, again, whether your landowner is in good faith or your landowner is in bad faith, the landowner must still pay the value of the materials. The only difference is if he is in bad faith, there is an additional obligation, and that is to pay damages. Now, what if the owner of the materials is in bad faith? If the owner of the materials is in bad faith, meaning he knew that the landowner was using his materials, but he did not complain, he did not notify the landowner, he did not tell the landowner, stop using my materials. He just let the landowner be. He just let the landowner use his materials. If the landowner is in good faith, then the owner of the materials is liable for any consequential damages without right of removal, whether or not injury would be caused. Why? Because, again, the owner of the materials is in bad faith. But still, the landowner should still pay for the value of the materials because, again, this is based on the principle against unjust enrichment. If your landowner is in bad faith and your owner of the materials is in bad faith, then you follow the rules as when both are in good faith, the rules we mentioned earlier. Because then, If both parties are in bad faith, you treat them as both are in good faith. Okay? So that's it for this video lecture. I hope you have learned the discussion on Articles 440 to 447. So for the next video, I will be talking about Article 448 because this is a very interesting article. So I will have one video lecture just for Article 448.
So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.